We are very excited to have Matthew Clair joining us. He's an assistant professor of sociology, not trained as a lawyer, but he does have a courtesy appointment in the law school. He's with us virtually from Stanford, so we're really delighted to have him. And I'm super, super excited to hear about his work. It's very cutting edge on the frontier of this work about mass incarceration. So Matthew, I will hand it over to you. As we have for other seminars, you can go ahead and type in your chat questions. He's generally asked to hold off on questions until the discussion time. But if you type in your questions and it's especially pertinent that you get clarification, I will go ahead and interrupt him to ask your question. But otherwise, we'll just go through questions during the Q&A at the end. So Matthew, please take it away. We're excited to hear about your work.
Excellent. Well, thanks so much. It's really great to be here with you all virtually at the IRP. And, Catherine, Jeff, thanks so much for inviting me. Thanks so much also to Dana and Dawn for organizing all of this and getting all of the technical aspects ironed out. I'm Matthew Clair, an assistant professor of sociology by courtesy law at Stanford University. Generally, I'm a cultural sociologist, so I study how cultural meanings reproduce inequality, reflect inequality, and then also potentially challenge inequality in the legal system in particular is where most of my work is focused. And so today's talk, I will be focusing on findings from my book, Privilege and Punishment, How Race and Class Matters in Criminal Court, which was just published 2 days ago. I'm very excited about. I'll be diving into one specific aspect of the book, looking at how disadvantaged defendants in particular interact with their mostly court-appointed attorneys, and the inequalities in that interaction, and then how it also reproduces inequalities potentially in legal outcomes. And so part of this talk is also contained in a paper that was just published in Social Forces called Being a Disadvantaged Defendant, which is sort of another lens of the data. And the book more broadly looks at disadvantaged and privileged defendants, not just disadvantaged defendants specifically. So when we think about the problems of the criminal legal system in the United States, we often speak of mass incarceration or the historically unprecedented rise in jails and prison in the United States over the past several decades. But there's also been a troubling rise in punitive legal techniques beyond the prison. Thus, we can refer to the crisis of the criminal legal system as one of mass criminalization specifically. And this term better captures the array of punitive legal techniques and institutions that have affected a broad swath of Americans in an unprecedented way over the last 40 years. Even among the relatively privileged, so this is middle-class people, white people, we've also seen greater involvement in the legal system, even as it has been mostly concentrated among the disadvantaged, specifically Black people, Latinos, and the poor. And the criminal courts are a central site of mass criminalization, where more than 17 million cases are processed in state courts throughout the country every year. So at the turn of the 20th century, America's criminal courts were notoriously arbitrary, racist, and corrupt. In the South, Black citizens were excluded from serving on juries, and Black defendants were tortured for self-incriminating testimony. Mass arrests and mob-dominated trials were routine. And meanwhile, in the Northeast, similar processes were happening, and they were targeted not just racially, but also had a specific targeting of newly arrived white ethnic immigrant groups and the working class. In the 20th century, as it progressed, especially in the middle of the 20th century, in the 50s and 60s, we saw the Supreme Court intervene in various ways. So the court extended Fourth Amendment and Sixth Amendment protections to defendants. In 1963, of course, we had the Gideon decision, which expanded the affirmative right to counsel in most criminal cases with the possibility of jail time. And a new wave of public defenders' offices were established across the nation. But despite these constitutional guarantees, researchers kept documenting high plea rates, a lack of adversarialism in the criminal courts. And meanwhile, federal and local governments shifted resources from social service provision, of course, toward the increasing number of punitive forms of social control, through the number of police officers, correctional officers, and court officials. And courts also saw an increase in caseloads and continued racial disparities. So recent research has begun to unpack these inequalities, largely through interviews of legal officials, ethnographic observations, and analyses of administrative data. Scholars have examined how courts today serve at least two sort of functions. One I refer to as social control, and other we can refer to as exploitation. So social control refers to punishments and legal techniques that attempt to control the behaviors of marginalized people and their communities. And then exploitation refers to practices that profit from these very same groups through court fines and fees. Now, while existing research on the courts continues to provide important knowledge about the perceptions and tools of legal authorities in producing social control and exploitation, recent research often overlooks the perspectives and experiences of defendants. And when defendants are considered, their perspectives are typically filtered through the eyes of legal officials, or they're mentioned only in passing. And so there's a general assumption in the literature that defendants, especially those who are marginalized by race or class, are generally passive actors in the legal process, and that their meanings and also their behaviors don't matter much. And so we're left with several lingering questions about how defendants navigate the court process and potentially resist legal authority. In particular, my research asks how criminal defendants experience court processing, how they engage with legal authorities, especially their defense attorneys, who are the main legal authority that they have interaction with throughout the legal process, and then to what extent they're able to resist various forms of legal control. And then last, I'm really interested, again, in social inequality, how and why these experiences and interactions vary by race and class. So I explore these questions in my book, and the book zooms in on the experiences of the court process today from defendants' perspectives and with respect to their interactions with defense attorneys, who are the main legal authority through which their court process is mediated. So I draw on in-depth interviews and ethnographic observations among an intentionally racially and socioeconomically diverse group of defendants, from an investment consultant to nurses and construction workers, to people who are unhoused and on public assistance and who are sort of the typical type of defendant that we might imagine in the criminal courts. And by comparing their experiences, I examine how race and class inequalities in daily life become embedded in the attorney-client relationship and are also reproduced through the court process. So in chapter 1, I explain the racialized and classed paths that lead to the same outcome, becoming a criminal defendant. I describe the alienation experienced by nearly everyone in the sample, rich and poor alike. Among the privileged, however, their social alienation and their resultant criminal behaviors were often overlooked by parents and framed as pleasurable diversions in their lives. Whereas the same behaviors among the disadvantaged were surveilled by police and were understood, and the meaning behind them was that they were necessary in a context of racism and poverty. The privileged were also more likely to report being afforded various kinds of second chances by police when they were stopped and questioned, and also simply being able to avoid police surveillance in the first place. Now, at some point, every single person in my study was eventually arrested, and that was one of the defining criteria of being able to be sampled in the study. And so they were arrested at some point in their life, regardless of their privileges. And so chapter 2 examines how the attorney-client relationship plays out for the disadvantaged in particular. In today's presentation, I'll focus mostly on some of the findings in chapter 2, as well as some of the findings in chapter 4, where I examine how the ways that disadvantaged defendants commonly interact with their lawyers are punished by legal officials and also by the institutional norms of the court. In chapter 3, I examine the experiences of the other side, the privileged. So this is middle-class people and white working-class people whose access to lawyers they can trust and whose surprising lack of knowledge about legal rights and court procedures, given their general lack of involvement with the legal system to begin with, enables what I refer to as delegation of expertise to their lawyers, which proves beneficial in their navigation of the court process. So to understand how inequalities are constituted and reproduced, I examine relational interactions. I theorize that defendants' actions and perspectives, including their exercising their legal rights to trial or motions, or deciding to take the witness stand, emerge not in isolation, but rather in relation to the actions and perspectives of legal officials, such as judges, prosecutors, and of course, their defense attorneys. And that these interactions are an important component of the feeling of inequality in the experience of the criminal courts. So relational theory in sociology has theorized how power and inequality are produced in interaction. And for relational theorists, social relationships at once constitute inequality and then also potentially reproduce it. So social relationships constitute inequality because they are often inherently unequal by definition. So for instance, what it means to be in the social position of middle class in American society means something in relation to other class categories, often working class or poor. So middle class people are defined by greater access to material and symbolic resources. And the same is also true between defendants and their lawyers and the social positions they occupy as defendants and lawyers, as well as the social positions that different kinds of defendants occupy, such as disadvantaged defendants or privileged defendants. And in addition, relationships also produce various forms of inequality through struggles over resources and then also through definitions of who belongs within which categories. Now, cultural capital theory also helps to understand the reproduction of inequality at the interactional level. So people's trajectories through various institutions, such as schools and workplaces, are shaped by cultural capital or dominant knowledge, skills, and dispositions that are valued by institutional gatekeepers. So this research has shown that in schools and doctors' offices, for example, there's been documented how the middle class people in these institutions are often demanding and entitled in their engagement with teachers and physicians. And that the style of engagement often results in rewards, whereas working class people and poor people, on the other hand, tend to be described as deferential in their interactions and are often penalized for their lack of institutional knowledge. Now, theories of institutional racism explain how these subtle forms of domination reproduce inequality. So seemingly neutral practices and standards that disproportionately reward one group or over another function to reproduce inequality under the guise of race and class neutrality and absent the blatant racist intent of any individual level actor. So my findings complement key insights from these theoretical traditions, but it also revises core assumptions of cultural capital theory. So specifically, I find that working class and poor people of color in my study have greater knowledge of their legal rights and are more actively engaged in their court cases in comparison to their privileged peers who have less knowledge of legal rights and are quite deferential in their interactions, both with their defense attorneys and in public court interactions. Yet despite the active engagement of the poor and marginalized, they're punished precisely for their self-advocacy. Thus, I argue that the institutional expectations that reproduce inequality, interactional inequalities in the courts are distinct from more mainstream institutions like schools, doctors' offices, hospitals, and workplaces. So to understand the attorney-client relationship, I rely on ethnographic and interview data collected in the Boston area court system. And I interviewed and observed scores of defendants and legal officials. And in Boston, 75% of the indigent defense caseload is handled by what's known as bar advocates. So these are private lawyers who are paid by the hour worked, but they maintain their private practices and they're paid to pick up people who cannot afford attorneys themselves. The other 25% of the indigent level caseload are handled by public defenders who are salaried state employees and who only work with people who can't afford attorneys. So I spoke to and observed defendants from a range of race and class backgrounds, and you had experience with bar advocates, public defenders, and then as well private attorneys. And for a month, I spent every day of the week as an intern at a public defender's office, shadowing 3 defenders, a Latino woman, a Black woman, and a white man, as they worked with their clients. So the goal of the qualitative analysis was to examine the experience of court processing, or what we might refer to as the how of inequality, and then also the processes that may account for disparities that we know exist in the aggregate level. So what we might refer to as the why of inequality. So in Boston, we know that Black and Hispanic defendants are overrepresented in district and superior courts relative to their share of the population. Statewide, Black people are incarcerated at 8 times the rate of whites, and Hispanics at 5 times the rate of whites. In research drawing on administrative data across the country, routinely finds that race and class disparities in conviction and sentencing are in substantial part unexplained by differences in charge type or criminal record. And my analyses provide one explanation of how these differences may be magnified along the court process. But I don't seek to assess the magnitude of effects, given that my sample is not necessarily representative. Instead, I rely on a case-based logic of analysis, seeking to develop logical theories about social mechanisms by comparing similar cases to one another, and then also different cases to one another. So this is a look at my sample of defendants in particular. It's quite diverse, which is an intentional feature of the sample. 32 of the defendants are white, 27 are Black, and 7 are Latino, and 1 is Native American. I grouped respondents into 3 socioeconomic status categories defined by their educational status and their employment status. So defendants' socioeconomic status over their life course varied. But at the time of their presence in the study, when I interviewed them, 11 of them were middle class, which I defined by having at least a 4-year college degree. 32 were working class, which meant that they had less than a 4-year college degree, but they had a stable routine job. And then 20 were poor, which meant that they had less than a 4-year college degree and they had intermittent work histories or they did not currently have a stable job. In interviews, I invited defendants to discuss more than one court case with me. So not just their most recent case, but also experiences with the courts at different periods of their life. So this allowed me to compare defendants' experiences, not just in relation to other defendants, but also in relation to themselves when they were engaged in prior court cases and had different access to various kinds of resources that may have varied over their life course. So in total, respondents discussed or were observed in 150 unique court cases. And this is really my unit of analysis, is the court case and the attorney-client interaction style in the court case. The unit of analysis is not really at the level of the individual. So as I analyzed the data, I identified 3 attorney-client relationship types, and I coded each case along those dimensions. I then examined how and why certain attorney-client relationship types appeared more common among disadvantaged defendants than privileged defendants. So for disadvantaged defendants, attorney-client relationships were more likely to be characterized by what I defined as relationships of withdrawal. So withdrawal is defined by distance and a lack of engagement and communication between lawyers and their clients. And there are 2 main types of withdrawal that I identified. So the first I refer to as withdrawal as resistance. So this occurs when defendants and their defense attorneys experience multiple moments of mistrust and tension that pull them apart. Mistrust of defense attorneys often arises from broader distrust of the legal system, including police, prosecutors, and judges, who defendants often have had personal or vicarious experiences of discrimination with. It can also arise from disagreement about legal choices or what the ultimate goal of the legal process is. So disadvantaged defendants are more likely than their privileged peers to have knowledge of and experiences with the law and various legal strategies that they've gleaned from friends and family, or their own time spent in jail, incarcerated in prison. And they often rely on their cultivated legal expertise, as I refer to it, to attempt to work around lawyers who they find are untrustworthy and to try to advocate for themselves. Now, there's a second type of withdrawal, which I refer to as withdrawal as resignation. So this is also defined by distance between defense attorneys and their clients, but such distance emerges more so from resignation to the legal process as a whole, rather than necessarily from a defendant's mistrust of their particular lawyer. Resignation is characterized by missed meetings and missed court dates, which frustrate lawyers and leave them unaware of crucial information about their clients' lives and also what their legal preferences might be. Resignation is rarely an intentional act of resistance among defendants, and instead, defendants who are resigned are often exhausted from simply striving to live under conditions of oppression within the legal system and then also in their everyday lives, where they're dealing with far more pressing matters than their court case, such as drug addiction, housing troubles, mental illness, and other issues. So mistrust is central to understanding characteristics of a withdrawn attorney-client relationship. So scholars across the social sciences have documented the importance of trust in facilitating communication and collaboration between people, especially under conditions of uncertainty. And of course, being charged with a crime is an immense condition of uncertainty where there are various legal options that have profound implications for one's life, as well as their experience of the court process. Moreover, when someone is arraigned in court and when they're assigned a lawyer, they're entering an asymmetrical relationship where the lawyer has much more power and authority within the court, of course, but then often in everyday life, especially if they're a disadvantaged defendant. So under these conditions, much is at stake for defendants, and their ability to trust their lawyer impacts the kinds of relationships they're able to have. Poor defendants' mistrust relative to their privilege could, of course, arise from poor lawyering or the idea that just the lawyers that poor people are assigned are just really bad at their jobs. But there's mixed evidence that the type of attorney a poor person is assigned to is actually directly related to their legal outcomes. Indeed, the few existing studies tend to suggest that public defenders may achieve better outcomes than their court-appointed lawyers who often practice in the private bar. So these would be bar advocate type lawyers. Meanwhile, these same private attorneys who pick up indigent cases, when they are defending clients who are hired or paying clients, they often may be able to achieve better outcomes for them. So this suggests that it may be less about the type of a lawyer and more so about the kind of relationship the attorney has with their client, and a relationship that, of course, is very much determined by and rooted in race and class inequality. So for the defendants in this study, mistrust arose from a set of conditions rooted in poverty and racism. So the perceived and real structure of the indigent defense system produced profound mistrust among the disadvantaged people I spoke to. They were skeptical of court-appointed lawyers' abilities precisely because they were part of the system, and they were thought to be underpaid. They were thought to be colluding with DAs, and they were thought to be overwhelmed by large caseloads, as these quotations from Royale, Robert, and Christopher reveal. Cultural differences between attorneys and their clients and experiences of prior forms of discrimination or current forms of discrimination when they get to know their lawyers also produced mistrust. So poor Black defendants in particular often reported feeling stereotyped by their lawyers, even those who were also Black. So for instance, Tim here, a poor Black man, was initially excited because he was assigned a Black lawyer in one of his cases. But they ultimately failed to establish a trusting relationship given their cultural distance and his sense that she was stigmatizing him as a drug dealer and that her class privilege was blinding her to his reality. Meanwhile, Slicer here in the second quotation felt that his white lawyer in particular was racist in a way that his Black lawyer was not in another case. Another source of mistrust is disagreement over legal strategies and goals. So disadvantaged clients often reported wanting to take different legal routes or achieve very different outcomes than the outcomes that their lawyers suggested would be in their best interest. So for instance, Troy, a poor white man, described his frustration here over being pressured to take a plea deal to probation, which his lawyer had insisted was a very good deal. And for William in the second quotation here, who was a middle-class Black man, but who grew up working class in both a working class household and neighborhood, he felt that probation was often a worse legal outcome than simply doing time in jail. This was actually quite common among many poor Black people in my study, particularly because they understood that living in a highly policed neighborhood meant that they were more vulnerable to police surveillance and being pulled in back into the criminal legal system when they were on probation. So they often felt that they just wanted to serve their time and be done with any institutional connection to the law and the legal system. So disadvantaged defendants who mistrust their lawyers often experience withdrawn relationships of resistance. And this unfolded over the course of their interactions with their lawyers, from the very first time they met them at arraignment to their conversations in closed door meetings and in courthouse hallways, and sometimes in the middle of trial. And so one example that I draw on and that starts and opens the book is the case and experience of Drew and his lawyer, Tom. So Drew is a working class Black man in his early 30s, and he's been arrested numerous times and has served several years in state prison on a gun charge. He told me that he's had, quote, a lot of bad lawyers in his life. When I met him, he had just been arrested again on a new gun charge. And he had been assigned a white male public defender who he realized immediately he did not trust. So during arraignment, the prosecutor in the arraignment session, in arraignment in Massachusetts, this is both a bail determination and also you're being arraigned on your charge. So the prosecutor made a mistake during arraignment. The prosecutor claimed that Drew had an open gun case, and thus, because he also had this open gun case that had yet to be resolved, the judge should set a higher bail amount for his current gun possession case. But Drew's other open case was not a gun possession case. It was actually a knife possession case or possession of an illegal knife. And so Drew was understandably upset. He feared that this mischaracterization of having an open gun case, which would be a more serious case than a knife possession case, would result in the judge setting a bail that he simply couldn't afford. And so he urged his lawyer to correct the prosecutor's misstatement for everyone in court to hear. But his lawyer didn't have a chance to do so before the judge ultimately ruled. And although the judge ultimately set bail at an amount that Drew could afford, he was angry. He felt that his lawyer was too passive and didn't take his concerns seriously. Now, luckily for Drew, he knew of another lawyer who he had come to trust a bit more. This lawyer was also a white male public defender. His name was Tom, and he was actually the person who was representing him on that open knife case. So after that case was ultimately resolved, Drew asked Tom to now represent him on the gun case. Tom agreed. For a time, they worked fairly well together. During one of their meetings at the public defender's office, I watched as they spent an hour and a half discussing Drew's new job, the details of his arrest, his allegations of police corruption, and possible motions that they might be able to file. Drew listened and he spoke excitedly at points when talking about the unfairness of the police stop. And it was Drew who had insisted that they pursue a motion to dismiss the charges on the grounds that the police did not provide sufficient evidence to the grand jury. He told Tom that he wanted to expose the officers' corruption through another motion as well, in which they would present evidence that the officers who stopped him had a history of racial bias in their police stops. So Tom listened throughout the meeting, but he did warn Drew that some of these motions might fail, that they may not be wise to pursue, and that they just wouldn't work. He said, quote, I want to set your expectations. Suppressions are very hard. It's hard for the court to deal with suppressing evidence. The court hesitates to not take in and accept police evidence. Regardless, Tom ultimately would never actually be able to argue these motions for Drew because the relationship would soon unravel. So over the course of the next several months, Drew and Tom experienced tension and disagreement. In one meeting, Tom suggested taking a plea deal. And in exchange for this plea deal, the prosecutor would drop one of the charges that had a mandatory minimum attached to it. And therefore, Drew would thus serve far less time in prison than if he were convicted at trial. But importantly for Drew, he had always been insistent on taking the case to trial no matter what. He didn't want to talk about a plea deal. Bringing up a plea deal was an offense. So Tom recalled he started to really push back. And later, during one of the motion hearings, one of the police officers did not show up to court. And the judge asked Tom and the prosecutor to come up to the judge's bench just to privately discuss where was the police officer, what was going on, are we still going to move forward today? Now, Drew wondered aloud why this conversation had to be private. The judge ignored his comment, and Tom whispered to Drew that he would share whatever they discussed at the judge's bench. But Drew, with his jaw clenched and his hands in his pocket, shouted out, but this is my life we're talking about here. As if to indicate, why does this have to be private? Why can't I be part of the conversation? The judge told Drew to take his hands out of his pockets. Drew didn't budge. Tom pleaded for him to comply. I heard him, Drew said, before slowly removing his hands. Now, after this incident, Tom decided to ultimately withdraw from serving as Drew's lawyer. Tom explained to me, quote, "I can't manage him and litigate his case effectively if at every moment I fear there's going to be an outburst that will intrude upon my litigation." On Drew's next court date, the court would assign Drew his third lawyer now in the case. And according to Tom, the lawyer on duty to pick up Drew's case is passive and not very competent. Drew's case could, quote, "drag on indefinitely," Tom suspected. Now, the other kind of withdrawal among the disadvantaged is what I refer to as resignation. So defendants who experience resignation reported similar levels of mistrust as their more resistant peers, but the difference here is that those who appeared resigned in court felt that the problems they encountered in their everyday lives were just more important and more pressing than the unique specific form of court involvement. So for instance, Mary, a working class Latina woman who struggles with addiction, mental illness, and unemployment, exhibited ambivalence toward her lawyer. She told me, quote, "At first, I did not trust him because he looked very inexperienced. And then later in the interview, she reflected that despite her reservations, she was, quote, trying to trust him. When I first observed her in court, she was quiet. The second time I was supposed to observe her, she didn't show up to the hearing, leaving her lawyer to apologize for her absence and then to make many decisions without any of her express input." Now, at first glance, Mary may appear disinterested to sort of, a court ethnographer or the casual observer, and passive, not showing up to court. But I later learned that she didn't show up because she had been hospitalized for problems stemming from her substance use disorder, as her lawyer would inform the judge. In our interview, Mary had mentioned to me her struggles with addiction. She mentioned how a couple years earlier, she had lost her job in customer service at a hospital. And I, quote, "just hit rock bottom. I went through a really bad depression and it completely changed who I was." Depressed, she started abusing alcohol, even though she found another job. She said, quote, "This last year I started drinking a lot." And her focus now was to kick her addiction first and foremost. Thus, defendants, I argue, who don't return their lawyers' phone calls, who don't show up to court, are actually often resigned to the broader legal process and view the adversities they face outside court as much more pressing. So legal officials and court norms punish attorney-client relationships characterized by withdrawal in both of these forms. So when it comes to withdrawal as resistance, one way defense attorneys and judges commonly respond is through silencing. So defense attorneys often silence their clients because they fear they may accidentally incriminate themselves or draw the annoyance of judges and ultimately harm themselves more than they're helping themselves. For instance, I observed a Black man become upset during his pretrial hearing. His court-appointed attorney was trying to make a motion to suppress video footage of his arrest. The prosecutor argued that the video footage should be included as evidence. At this suggestion from the prosecutor, the defendant shouted out in open court, "Man, I'm only one person. I can't fight 4 officers." His outburst was an attempt to articulate how his actions did not meet the legal definition of resisting arrest. But at this point, the judge was visibly annoyed. Yet to hear full arguments from the ADA, she said, "Please speak through your attorney, sir." His attorney tried to quiet him, but he rebuffed his attorney. He turned to him and yelled, "Look, man, I didn't resist arrest." His lawyer yelled back, "Stop talking. Why would you do this? Why are you doing this? Stop talking." The judge interrupted their squabble and said, okay, second call. The lawyer said, "Thank you, Your Honor." And he muttered this as he and his client brushed through the gallery and out into the hallway. And as the doors closed behind them, I could hear the muffle of the lawyer's shrill voice publicly reprimanding his client. Defendants who disagreed with their lawyers' legal strategies often felt coerced to go along with them. So for instance, it was quite common for defendants to want to file motions in their cases and for their lawyers to pressure them not to or to rethink that, or simply to refuse to do so. So Kevin, a working class white man, described the futility of trying to get his lawyer to file motions in his case, telling me that his lawyer refused to do so because the judge likely would not rule favorably on the motion. I also observed a working class Black defendant lose access to his lawyer and be denied a chance to be assigned a new court-appointed lawyer, precisely because of his resistance to his original lawyer, who he claimed was unwilling to even unwilling to file motions on his behalf. So as this excerpt from my field notes reveals, the judge, who has discretion to assign the defendant a court-appointed attorney at any time, was simply just annoyed by the bickering that he saw between the defense attorney and the client in his courtroom. And so he simply refused to assign this defendant a new lawyer. And to add injury to insult, he also refused to extend the time that the defendant had before his next court date, which would have helped the defendant have more time to try to get together some money and find and hire a new lawyer. Now, resignation also has negative consequences that are unique. So withdrawal as resignation often results in a lawyer's lack of knowledge about their client's needs. It often results in default warrants for arrest for simply not showing up to court, a far lengthier court process, and an increased likelihood of picking up new cases while other cases are open, and thus creating a record of non-compliance with the law. Now, many lawyers also simply respond to resigned defendants by delaying working on their cases. So defendants who appear like they might potentially be resigned in their interactions tend to have a different kind of legal representation from their lawyers. So Sybil, one of the public defenders I shadowed in the study, described how she can, quote, always tell when she's, quote, never going to see a client again. For those clients, she doesn't prepare motions or make other preparations for their pretrial hearings. She doesn't want to waste the time, given the time she has to devote to her other clients who are more engaged and are showing up. Although withdrawal tends to have negative consequences, there are some benefits, specifically of withdrawal as resistance. So one benefit of resistance is the articulation and creation of alternatives to the dominant court record. For disadvantaged defendants living under constant police surveillance, their processing in criminal court is often seen as an opportunity to set the record straight and to resist symbolically unjust criminalization and potentially materially if they win. For them, their legal sentence can be of secondary importance to their own and their community's dignity and survival. So for instance, here, Joe told me about how his arrest alongside his co-defendant, Bob, violated their Fourth Amendment rights. They were stopped by the police after a drug exchange, but the police record had lied. It said that they were caught with drugs on their person, but Bob, however, was not caught with drugs on him, as he disposed of the drugs before he was arrested. And he believed there was no evidence that they knew that he had exchanged drugs or that he had them on his person. They lied and lied and lied and lied and lied, Joe told me. Now, Joe ended up agreeing to a plea deal to probation. But Bob, on the other hand, wanted to fight the case because he wanted to force the officers to lie on the stand, and he wanted to have a chance to contradict their lie in court. He ultimately lost the case, and he spent 2 years in jail, far longer than the probation time that Joe had for the same crime. Now, Tom, one of the public defenders I shadowed, told me that for some clients, all they want to do is expose what the cop did wrong. So I discussed several theoretical implications of various aspects of the findings in the book, but today I'll just focus on two main ones. So first, the findings offer greater insight into the how of inequality, or into describing the experiential qualities that are constitutive of what it means to occupy a disadvantaged category and social position within the courts, and also within broader society. So I show how mistrust, disagreement, silencing, coercion, and simply being lost in the system are defining features of what it means to be a disadvantaged defendant. I also suggest that these characteristics likely reproduce inequality in legal outcomes, such as one's sentence. So interactional dynamics are a basis on which lawyers and judges discriminate between defendants. Defendants who are resistant or withdrawn are punished, whereas defendants who delegate authority to their lawyers, which I didn't describe today, are rewarded for their compliance. I argue that this revises cultural capital theory and research on schools and doctors' offices, which has shown that working class and poor people are deferential and middle class people are agentic and demanding. Here I find the opposite is the case. Second, my findings underscore how interactions with legal authorities function to reproduce legal power. So despite their mistrust of legal officials, many disadvantaged defendants maintain actually a surprising faith in legal tools, such as motions to dismiss or suppress evidence or trying to take their case to trial. Ultimately, their resistance to legal authority thus relies on and therefore bolsters the durability and power of the court and legal tools. And so this presents a paradox of legal control. The more defendants seek to directly fight their case, the harder their lives become. So the problems that I've uncovered in Boston, which is actually a relatively well-resourced indigent defense system compared to many others in the United States. So these problems that I've uncovered, I see as probably more extreme in other jurisdictions. Therefore, my findings suggest that greater investment in bolstering indigent defense systems, while important and while helpful for many at the individual level, will likely not be a panacea for bringing about justice, at least not the kind of justice that defendants want to see. So in the book's conclusion, I reflect on 3 levels of transformation required to bring about justice in the criminal courts. And these include changes at the interactional level, in the nature of the attorney-client relationship itself, at the institutional level, in the norms, procedures, and expectations that judges, prosecutors, and defense attorneys have come to take for granted as the way that the courts should operate and as various legal tools should function. And then I talk about transformation and potential abolition at the societal level, in the way that we deal with criminalized social problems and harms to begin with. And I invite readers to consider what abolition might mean in relation to the criminal courts process, not just in relation to policing and incarceration. So I'd be happy to discuss much more about any of these topics, but especially these levels of transformation in the Q&A. But that's all that I have for now, and I really look forward to your questions.
Great, thank you, Matthew. That was really interesting. We do have one question already from Mallory, which I will go ahead and read, but I want to encourage other folks listening to either use your hand raise or go ahead and type in your question. And Mallory asks or says, I'm interested in the characterization of withdrawal as resistance. It seems more active than passive, given the examples you've offered here. What is your logic behind grouping this set of cases, which seem to be about inappropriate engagement in the court process, with those that are more about disengagement?
Great. And so withdrawal is, and that's a great question. So withdrawal is to characterize the relationship itself. It's a relationship where people are being pulled apart from one another. But what constitutes that pulling apart for withdrawal as resistance is agency, understanding legal rights that should exist on the ground and being frustrated when they don't exist on the ground, right? And then what characterizes withdrawal as resignation is the resignation component. What characterizes that separation is not necessarily an agency or frustration or resistance, but more so simply not thinking that the court process is a defining central thing that needs to be focused on when they're dealing with drug addiction, mental illness, or simply finding where to sleep each night. And so the withdrawal language was intentionally meant to characterize the separation between attorneys and their clients, given my focus on interactional relationships. And then the resignation and resistance parts describe the more sort of resigned nature and then the more agentic nature among some of the disadvantaged defendants. Thank you for that question.
That's great. I think I would love to hear more about how you see transforming the court itself, right? So the rules and the norms and the expectations seem very specific, but not transparent, if you will. Yeah, so I'd be curious exactly how you think that gets changed or how it should be changed. I'd be curious to hear more about that.
Yeah, that's great. So some of what can be changed at the institutional level is simply about the way that we assign public defenders to disadvantaged clients, which would really help in solving this issue of mistrust that begins immediately at arraignment. So right now, in most jurisdictions across the United States, you have no say in who your assigned court-appointed lawyer will be if you are a poor person in the United States. You show up and they randomly assign you, the clerk randomly assigns somehow, and you have no insight into that. In Boston specifically, usually about depending on what court you're in, if there are 4 lawyers on duty that day, 3 of them are going to be bar advocates. One of them is probably going to be a public defender on average. And the court clerk will have randomly assigned beforehand who's going to get which defendant. And then the defense attorney looks and then at their case file and then goes to speak to them. It would be great if instead of that random assignment, defendants could just have some say in who their attorneys might be among the 4 who are up there. Maybe they know attorneys from previous interactions that they've found that they can really have meaningful relationships with. And of course, that would have some issues for sort of the procedure of and sort of the everyday routine of justice in the courts. Clerks might be frustrated initially, judges might be as well, and slowing down their docket. But I think that is really meaningful for people to just have a sense of, I got to choose and have a sense of who I wanted. And then I think there could also be a valve where potentially allowing people to have 1 or 2 opportunities to select a new attorney if they find that they're in a relationship that they simply find that is not working out. And in the public defender offices in Boston, there is sort of an informal reassignment that can occur if a defense attorney, from their perspective, feels that a relationship is on the skids. They can informally say, hey, could my colleague take this person? But that's really, very ad hoc. And it's also from the defense attorney's perspective at this point, rather than from the defendant's perspective that they feel that there is some lack of engagement. The other institutional norms that can be changed is just the way that judges are in their willingness to entertain certain motions to dismiss or suppress evidence. Right now, judges are very deferential to police practices. They believe on average in the United States, and this has been built up through various Supreme Court decisions, but then also just judicial culture. There's a sense that police know what they're doing and that judges should defer to their expertise and their understanding of what counts as reasonable suspicion and probable cause for an arrest. Judges, I think, could have much more of an influence in checking the decision-making of police, and then, of course, also prosecutors who generally at the lower level kind of typically rubber stamp what's happening coming from the police department. But then even when they're indicting and going to a grand jury, I think judges could have much more of an influence in dismissing certain charges or suppressing certain forms of evidence that were collected and that violated Fourth Amendment law. And so reinterpretations of Fourth Amendment law, I think, is one way. And that's just the institutional level. I have many more thoughts on the societal level, which would be much more transformative and radical, but I'll save that for now and see if there are any other specific questions.
We do have one. So okay. Jacqueline writes, really interesting. Thank you so much. We'll definitely be purchasing your book, so that's good. Did you hear more from court-appointed attorneys about what changes they thought might help? I have some who really care about these issues, but not sure what to do about it.
Yeah, let me tell you, the 3 defense attorneys who I got to know are truly wonderful people and truly deeply engaged. And I talk about this in chapter 4. Their motivations for going to law school were very much for all of them about racial inequality and injustice, wanting to change the legal system from inside. They really are frustrated by the type of justice that their clients receive. But they are working within a system at the sort of individual level that they cannot structurally change in their everyday interactions with clients. And so their main goal is to just mitigate the worst possible legal outcomes that their clients could face. But I do think, and legal scholars have theorized concepts such as resistance lawyering and other kinds of lawyering and litigation, impact litigation, of course, but things that can happen at the appellate level that lawyers could do, but then also things that lawyers can do in their everyday lives outside of their interactions with their clients. And of course, asking public defenders who already have immense caseloads and are super overwhelmed to, march in protests and advocate for legal changes outside of what they're doing is a lot. But at the same time, many of the public defenders who I spoke to were really involved in politics, really involved in, while I was in the field, we had a new ADA, progressive prosecutor elected, Rachel Rollins, and they were excited about the possibility of that new election, about her possibly declining to charge certain cases that they have seen routinely go through the system that they feel like should just not be charged to begin with. And so, they were involved, many of them in of course they voted, but also sort of organizing on the ground. And so I think that's really the way that public defenders can make change, rather than sort of what they do in their everyday level, engaging with clients, because it's really about a systemic failure rather than sort of individual level failures.
Great. I was curious to hear a little bit more. So you talk both about race and about class. And clearly, if we could read the book, I'm sure we'd learn a lot more. But I'm curious how you're thinking about the intersection of the two and sort of where do you see that intersectionality being impactful, meaningful, or not?
Yeah, that's a great question. So both definitely matter. And I think that, so, I opened the book with a case of two defendants, Drew and Arnold. They're both Black men. They both have gun possession charges. One's middle class, one's working class. And they have different relationships with their lawyers, and they also have completely different legal outcomes. Arnold ultimately is not convicted at trial. He went to a jury waived trial, basically a bench trial where a judge decided, and he ultimately was found not guilty. So I actually use that as a way to open up a conversation and have a more nuanced conversation about how class does matter. But race very much matters. And we know in American society, of course, people who are slotted at the bottom of the socioeconomic ladder are disproportionately Black and Latino. And so, talking about class without talking about race is just impossible. And then also the way that neighborhoods are segregated is super important in this conversation as well. So the defining features of what brings about preceding levels of mistrust of the legal system broadly, but also, or distrust of the legal system broadly, but then also mistrust of your new assigned lawyer has so much to do with the quality of the legal system that you've experienced in your neighborhoods and your communities with policing, and then also the vicarious experiences of your family and friends. So for Black and Latino people who are living in disadvantaged neighborhoods in Boston, you're just so much more likely to be involved with or have friends involved with the legal system than for working class white and middle class people of all racial groups who are living not in majority Black neighborhoods. So it's, there's no either or, it's definitely both and. Both race and class are super important in understanding the quality of injustice in the courts.
There's one more question, but I'm going to throw in, and gender. So
yes, great question. Yeah,
how did gender?
Great question about gender. I regret not asking specific questions in the interview about gender. I asked people specific questions about race and class, but I didn't ask specific questions about gender. And my sample was really small with respect to the number of women. I interviewed 7 women, but then I think there were 11 women given the number of women who I observed. And women on average in my study tended to be more well off. So it was hard to disentangle what was about gender and what was about class. But we do know from amazing research that's existing, that has been done, the different ways that gender matters, especially intersectionally for Black women and white women. And in my study in chapter, the privilege chapter 3, where I start with the story of Brianna, who's a white woman who is very privileged in many ways with her interaction with her attorney. And at one point, her attorney refers to her as a cute white girl, as a way to describe the likely treatment that she will receive in the courts, her recognition of this treatment, given her gender and race intersection and how that might operate in people's minds. So gender definitely plays a very important role. But to be the most faithful to the data that I could possibly be as a rigorous sociologist, I hesitated to make strong claims about gender differences in a way that I do make much stronger claims about race and class, just because my data is much clearer on that. But I very much think that gender likely matters in various interesting and complex ways. And, I also have stories of Black women who do not receive the same benefits that white women do. They're often misrecognized, forgotten who their lawyers are. I have scenes of lawyers not even recognizing or differentiating between the different Black women who are in the gallery who might be their clients. So gender definitely plays a role here too.
That's great. We have a few more questions. So Liz Dovey asks, did you speak to any defendants who had positive experiences with their lawyers, agreeing to the approaches they wanted to take, motions, going to trial, etc.? Is there a sense of whether, if there were indeed adverse outcomes, whether they were nevertheless satisfied because of the better relationship?
Great question. So yes, I did. And so chapter 3, which I was just describing, where Brianna opens that chapter, is the chapter all about the privileged and all about the positive relationships that they are able to form with their lawyers. Often these are private attorneys, but not always. Sometimes working class white people in particular, they may have a gap in their employment history, or so they may report a low income, or they just may be assumed to not have enough to afford an attorney. And actually in Boston, it's actually quite liberal in the way that it allows a larger number. There's sort of a quasi-indigent category where you can be assigned a court-appointed lawyer and you can pay a small fee. So anyway, a lot of people have court-appointed lawyers, even if they're working class and have somewhat of an income. And so among those people who are more privileged on the working class white side of privilege, I saw also this sort of privileged interaction with their attorneys. And that was characterized by first, a general inexperience with the law in comparison to the disadvantage. So they're just much more likely to ever had any interaction. They might have a one-off case, and that's their first time interacting with their lawyer. So they're inexperienced, and one defendant referred to it as a naivete with the law. And he says, I never thought I'd be in that situation when he was describing it to me in the interview. And so they recognize they actually don't know anything about the law. And so they're super shocked and worried. And so it leads to a willingness to listen to lawyers, a less of a skepticism that lawyers are not going to do right by them, right? There's an assumption because they're privileged that lawyers are looking out for them in a way that we don't get among disadvantaged defendants. And so the relationship is much more consensual. There isn't a pulling apart. And you're right, even when they have negative outcomes, and I talk about this in the book as well, they feel that because their relationship was good, they at least don't blame it on the attorney-client relationship. And also they're much more willing to sort of accept punishment precisely because they are more likely to be pulled. They are less likely on average to be pulled into the system as privileged people. And so when they are pulled into the system, they actually probably did do something wrong, and they recognize it in a way that a lot of poor people who are just driving through their neighborhoods and are stopped by police, they feel so frustrated by constant engagement and involvement in constant sort of like negative, like instances where, maybe I did something slightly wrong, or like, actually, you didn't catch me this time. I didn't do anything wrong this time. This is super frustrating. And so there's a sense of unfairness that a lot of privileged people don't have immediately in their interaction with the system. It's almost an agreement of, yeah, okay, you're right. You caught me. I did do something wrong that I've been getting away with for a very long time.
Steve, I see your question, but I think Jordan's is a good follow-up to the last question. So I'm going to read his first. So Jordan says, hi, Matthew. It's Jordan Conwell.
Yes, hi. I look forward to being with you in a bit.
He also says, thanks for the great talk. He's excited to read the book as well. And he says, I'm interested in your general theoretical argument about deferring to experts such as lawyers as a form of privilege for middle-class defendants, as you mentioned in your intro. I agree that when we think of class privilege in institutions, it is about intervention, like the many examples of parents and schools that you cited. And he says, so courts are different. Are there any other institutions that you think where deference as privilege might also apply?
Yeah, that's great. So I think Child Protective Services. So Jennifer Reich has a fantastic book on the welfare institutions and how deference is definitely something that's valued. And I think, we also see this potentially in other institutions where where punitive logics might be infusing. And so, I think the cultural sociological literature on schools, it tends to focus either on elite schools or, elite universities and interactions with professors, or, suburban, well-resourced schools. But, I wonder, and I'm curious too, and maybe we'll have a conversation about this a little bit, Jordan, but I'm curious about, no excuses charter schools. I'm curious about schools where there are just like more punitive logics increasingly fusing, and whether deference might be something that's characteristic. Of course, these schools are more homogenous, right? So schools are segregated, and so they're more homogenous with respect. There's less race and class diversity, but where there is, seeing how those different interactional styles might unfold, and whether deference does afford some sort of advantage and agency, and intervening accrues some sort of negative response, would be really interesting. And I talk a little bit about potentially exploring these other sites in the book, because I think that, one feature of this term of mass criminalization that I refer to, and I'm engaging also with the work of a lawyer and activist Deborah Small, who talks about the term mass criminalization. It's funny, I came up with the idea and then I Google it and I'm like, oh, someone else has come up with this, right? So, and I think her conceptualization of mass criminalization is slightly different from mine, but it's really fantastic in that it really unpacks how we shouldn't just be thinking about punitive legal systems and their forms of criminalization and these institutions that are punitive, but also think about how logics are infusing in historically or hopefully, not necessarily historically, but hopefully non-punitive institutions such as schools, workplaces, and the way that we treat people. And so looking there as these logics are diffusing could be one way to unpack whether this deference and delegation versus withdrawal and resistance plays out differently in different places.
That's great. Steve Cook asks, the observations here seem to have occurred in a location where the public defender system was pretty robust. There are many jurisdictions where public defender systems are far less developed. Can you speculate on the way your observations might have been different in a different locale?
Yeah, that's a great question. And, I really think about this too, just thinking, I'm from the South, I grew up in the South, and thinking about Southern criminal courts, their history, but also their present, speaking to friends who've worked, in New Orleans and friends who are currently working in Austin, Texas, where there was just a public defender's office established through a lot of work done by people on the ground there just this past year. And so it's amazing, as much as we sort of see the public defender idea as validated in American society these days, there's a lot of resistance in certain legal communities, especially from the private bar. I think the public defender does a few things. I think institutionally, it happened in Massachusetts, what the public defender institution does is it puts a new institutional capacity in place that sort of is standardizing practices of good indigent defense. And so in Boston, the bar advocates, who are private attorneys, are actually partially trained with each incoming new class of public defenders. So if you are a private attorney who wants to do indigent cases, you take part of the public defender training and orientation. You also have access to some of the social workers and investigators that the public defender's office has access to in Boston. Of course, whether you actually draw on those resources is another question, but at least you have access to them. And so the institutional capacity of the public defender's office, I think, allows for much more robust engagement in client-centered advocacy and even potentially holistic advocacy, where you might be able to in some instances help people with their everyday struggles in their daily lives. Of course, this doesn't always happen, and I find that even though we have this robust system in Boston, we still have problems. And so I'd imagine in other places where we don't have an institutional public defender's office, the quality of justice is going to vary wildly and widely based on who your attorney is. I'd imagine the range of private attorneys who pick up indigent cases is just so broad that the quality of justice is really going to be very different depending on who your attorney is.
Yeah. Okay. I think I get the last question, and admittedly, this might be a hard question, but maybe not. So I'm curious to hear your thoughts on how your work fits or maybe doesn't fit with the work of Jamila Michener. So she's writing about civil litigation and how it affects people's sense of democracy and civic engagement. And so I'm curious, obviously a different type of court that they're involved with, but if you have any thoughts on how this then shapes people and their civic and sort of sense of democracy at the end of their experiences, right? So you sort of talk about it as they're coming into it, having had different experiences before they get into court, but how do you think their court experiences shape them when they're done with it?
Yeah, that's a great question. The political science literature, I think, has been really great on analyzing and showing how, police, courts are a form of government, or a form of the most common form of government for some people, right? And that shapes their understandings of interactions of what it means to be a citizen in a democracy is so profoundly shaped by that interaction. For the people in this study, I think that's right. I think that's also what they take from the courts. There are also sociologists who are engaging with this work, like I think of Chris Eugen's work, of course, and others who I engage with as well in the book. And I think that is true, that it's not just about slotting into the system and then the quality of justice in the system, but when you leave the court, you leave with a feeling of mistreatment and injustice. And I don't make a claim that this sort of relates to their sense of democracy necessarily, but I do make a claim that this relates to their fundamental understandings of racism and classism in American society. And I think that the courts are a very important and increasingly important institution that people are coming into contact with, and that increasingly diverse set of people are coming into contact with. The scope of criminalization has expanded beyond urban areas and more rural and white areas. The number of people with college degrees who are pulled in the criminal justice system has increased. Of course, it's very small still, but it's increased to a certain extent. And so as more and more people have interaction with the courts, they're seeing this as just another institution that is validating in many ways the injustices that they may face on the basis of race and class in schools, in the workplace, in their interactions with other sort of street level bureaucrats, and potentially in their understandings of democracy. It's a really great question.
Well, thank you. And I'll give you just the final word if you want to give some light as to how you would transform society more generally. I think we'd all love to hear it.
Oh yeah, of course.
Then we'll let you go.
Okay, well, thanks so much. Yeah, I think we've all been enraptured and hopefully inspired by the Black Lives Movement, the spring, summer, fall, still continually. And, I think so much of the movement has shifted its sort of central focus, in the sort of Obama era, it was very reformist. And now we've really are talking about and centering abolition, defunding of police. And, of course, this has been happening for a long period of time, since the 60s, the Black Panther Party, Angela Davis's work. In the 90s, we had critical resistance. But really, the center of the conversation is coming to an understanding that something is fundamentally and potentially unreformable, fundamentally wrong and unreformable about the legal system and aspects of it. And so what I do in the book at the end is I invite readers to have a conversation and think more critically about the criminal court is also a problematic feature of the legal system, not just police and prisons. And of course, organizers have talked about the criminal court to some extent, and the Movement for Black Lives policy platform talks about pretrial detention and bail issues. But I really think having a more robust conversation of the criminal court is important, because often when we have an officer-involved shooting happen, people turn to the courts as potentially a site of justice, but we know that obviously these people are rarely charged, but also much less often convicted. And the courts really are perpetuating social control and exploitation, as I sort of mentioned at the very beginning. And they have a history of racism and class domination that I think we need to really articulate as well in the conversation around abolition. It's not just that policing has a racist history, or incarceration does, so too do courts. So anyway, what I think transformation could look like would be a lot of leaning into what organizers are talking about with respect to police and prison abolition generally, which is moving to restorative and transformative justice approaches, moving toward prevention of criminalizable social harms and problems through investment in education, housing, things that, good social scientists have been talking about for decades, things that we all seem to know, but there's little political will to get behind often. And so investments in those things, but then also sort of an understanding that harm may always be with us. That's part of human life is, people harm one another. And we need to really have a conversation about more positive ways of dealing with social harm and reincorporating people into society. And I think restorative justice approaches are one possible way. Of course, there are limitations to how they currently exist because they very much depend on a prosecutor allowing, giving exceptions for people to go through restorative processes, to go to restorative courts like peacemaking courts in New York and other programs. But I think if we move that to the expectation and the norm rather than the exception of, okay, when someone commits a social harm, even a really violent one, we really should start from how can we restore healing between victims and offenders, rather than how do we separate people and sort of convince people to just plead guilty, not admit fault, right? Defendants often want to admit fault and want to have some sort of reconciliation with their victims. And victims also, I talk about in the book, are really not getting justice that they want from the courts either, because of the way the system is set up adversarially. And so I think a restorative justice process and transformative justice is really, hopefully, the way we can move forward. But yeah, thank you so much for having me. I really appreciated getting to talk to you all.
Well, thank you. This is a terrible thing to say to someone who just finished writing a book, but we look forward to having you back when your next book is finished.
Oh, man. All right. Give me a decade. I'll see you then.
All right. Thank you very much. We enjoyed it. Bye-bye.
Bye.